Welcome back to Daybreak, of course, the program that brings you what you need to think about as you begin the day. And today we are talking law and corruption. My guest is already here, the Law Society of Kenya President, Alan Gichuhi.
Hi, Sam.
How are you?
Happy New Year. Thank you. Happy New Year to you.
Welcome to Daybreak. This is your first time on this show?
I believe so, but I've been here on a few occasions in the past, in the evenings particularly.
Okay, all right, yes. Great. So we'll be talking about that shortly. But first, we want to recap the story that we are talking about the Democratic Republic of Congo, where an opposition leader has won that election. Of course, after contestations from different parties, we'll be expecting that developing story to see how it pans out. And as far as the Electoral Commission, after announcing those results, we'll be focusing on it to see how that transition goes. President Kabila, the first time that he'll be leaving office. He's been in office for 18 years, and this might be the first transfer of power, a democratic transfer of power since that country gained independence in 1960 from the Belgians. Right, let's now focus on the topic of the moment, that is law and corruption. We are talking about a situation that we have seen the past few months, since I believe April of last year, when the new DPP Nordin Haji and the new DCI George Kinoti came into office, and I've seen some reignited war against graft. First of all, I just want to ask you from a lawyer's perspective, when you look at that war, which is now how many months? 9 months. Mm-hmm. What's your feeling about it? Are we on course, and how well are we doing?
Well, actually, it's, I must say, when you compare the tenure of the current DPP and the previous DPP, there's really a world apart. The world apart in terms of aggressiveness. With the current DPP, let's say the combination of Kinoti and Nur has been quite interesting in the sense that for the first time we've seen a lot of corruption cases being hauled to court. And this has never happened in the past. And as lawyers, I think, and as citizens of the country, mm-hmm. we applaud the fight against corruption. Let's be very clear on that. In fact, the other joke the other day I had with Nur, because I sit on the DPP advisory board, when mm-hmm. he says, look, I'm creating more employment to you lawyers because I'm taking more accused persons to court. But the point is, it's really high time that we actually got to the bottom of corruption. Mm-hmm. As Justice Ringara said, the dragon of corruption has to be slayed. And we have to do it. I mean, when you look at the hundreds of billions of shillings that go to waste through corruption, it's heartbreaking. Mm-hmm. When you think of the poverty that could be eradicated because of this. And I personally am a firm supporter of the fight against corruption. And to make it clear, we always say that every fight has to follow a constitutional bedrock. Mm-hmm. So that the rights of the citizens to ensure that the corruption dragon is slayed are secured. At the same time, the rights of accused, because remember the presumption of innocence mm-hmm. is enshrined in the Constitution, should also be upheld. Right. So those are the factors that we have to look at and have a balancing act on it.
When the DPP speaks about his progress, the progress that he has made since April 2018, most of the time he'll blame the judiciary for derailing this fight. He says that it's sort of giving breaks or giving space for the accused persons to manipulate the justice system. Mm-hmm. Where do you sit with this kind of argument?
Well, to be honest, I think some of those comments may be a bit rash in my opinion, because if you look at the past, you'll find that some of the accused have even had difficult problems in getting bail terms approved. Some have been held in custody for quite a long time. One thing we have to understand is that, as you rightly pointed out, this fight against corruption began in earnest when the DPP took over. Mm-hmm. Now, most of these cases have not even started mm-hmm. full hearing. Now, let's appreciate one thing. There are a lot of suspects who have been taken to court, number one. Number two, we have a limited number of judicial officers who can handle all these cases. Mm-hmm. I mean, the resources are stretched. Right now, one of the things that we really hope that the JSC will do is to increase the number of judicial officers. But coming back to the point, very few of these trials, as I said, have kicked off. Now, let's wait for the trials to kick off, mm-hmm. and then we can comment. Once the trials kick off, we'll see what evidence is on the table mm-hmm. and how the judges and magistrates are going to rule on those cases. Right. But it's a bit premature to say that the judiciary is holding back mm-hmm. on corruption.
And I say that because also the president sort of insinuated to that on his interview with the media. I believe it was on 20th of December 2018. And he came into the new year with a vow that he's going to ensure that the property of those persons that are accused of corruption is confiscated through the Assets Recovery Agency. But getting back to the prosecution, you're saying that the full hearing hasn't begun in some of these cases. And
yes.
there are reasons. Some of them is because the DPP is not ready to proceed. But also on several occasions, we've seen that the accused persons going to a higher court to contest their prosecution. So how do you explain to a Kenyan who is looking forward to seeing people arraigned, the full hearing and convicted or acquitted, how do you explain to them how the lawyers will be facilitating such kind of a process of appealing against a prosecution?
Well, the thing is, there is the right of every citizen to go through the due process. Now, there are certain instances, for example, that an accused person will feel that, look, I think these charges against me are malicious and I want to challenge them. And the various factors that the courts will consider. Now, the minute, for example, you've been charged before Magistrates Court and you rush to the High Court, you get a temporary stay, we have to obey court orders. So the process will be stayed until the appeal process is determined. Until the logical conclusion of the appeal process is concluded, we have to abide by the rule of law. I mean, you can't come over and complain about a process where, for example, take for example the recent Court of Appeal decision where the Kenya Revenue Njarine was won on appeal when the two judges of the Court of Appeal say that the process of initiating the prosecution was actually unfounded and the judge should actually have stayed the prosecution. We have a delicate balance where the courts will have to look at the facts of the case. For instance, are some of these charges malicious that would warrant the court's intervention to quash them? Because we've had several precedents in the past. Like, for example, you may be facing a crime that happened 15, 20 years ago. And at that particular point in time, the prosecution said that we don't have evidence. 15, 20 years later, they come over and say, now we have evidence. Where would you manufacture evidence 15, 20 years later? That is where the court comes in and intervenes. So the problem we have at the moment is that we prejudge persons. Look at the NYS. 11 were released because of lack of evidence. Now,
though the DPP has contested that and said that it was not because of lack of evidence, and he says that he has the right to withdraw charges against an accused person, and he actually said that out of those, I believe there are 7 have now agreed to be state witnesses. Yes,
but you see, the circumstances, what was out there in the public media is that there was lack of evidence, and that's what led to the withdrawal of charges. Now, those are the kind of instances that we have to look at, because I can assure you, one day, let's say you're arrested and there's insufficient evidence. How would you feel if you're arrested on a Friday? Spend 3 nights in a dingy police station. And remember some time back, some of our MPs were incarcerated in Pangani, and they came out and said, we are going to push for reform, we're going to fight for better conditions for accused persons in the police stations. Have we had anything from them? Nothing. The point is this: it is the right of every citizen to also seek whatever avenues the law provides to vindicate their rights. It's also the right of ordinary citizens to feel aghast that why is this process taking too long? But we have to appreciate one thing: the judicial process has to follow a certain cycle. If you have an appeal and there's a court order, obey it until that appeal is exhausted. The only thing that we would ask for is that these appeals are heard expeditiously and there's a speedy conclusion to them. Because it's not rocket science as to what factors you need to meet in order to stop or quash a possible charge.
I want to briefly highlight some of the cases that are in court. Of course, we may not go into details because they are already in court. And the first one is the one facing the Deputy Chief Justice, that is Philomena Mwilu, who is supposed to be prosecuted over charges of quite a number of charges, including abuse of office and benefiting from proceeds of crime. She went to the High Court to contest that prosecution because she feels there should be other avenues of investigating such kind of a matter. Now, we are at a position that even that case at the High Court cannot begin because the DPP appointed Queen's Counsel to come and represent him. Then there's opposition to that. So for a Kenyan, an ordinary Kenyan, they do not understand all this that is happening. Of course, it's within the law according to the country's laws, but for an ordinary Kenyan, they do not understand why we have to go through all this drama and haggling within the courtrooms, how do you explain to them?
Well, as I said, it's still the same old process I just explained earlier. Once you're aggrieved by a particular course of action and you take the right to appeal or review a particular decision, and the court is seized of that, then the court will have to deal with it. We have to appreciate that fact. You can't, for example, have two parallel proceedings going on. Like the prosecution goes on, there's an appeal and there's a stay. The minute there's a stay, you stop the prosecution. That's the law. And whatever you may be dissatisfied, but that's a procedure to follow. For example, what if you succeed on appeal? That means the law court case will collapse automatically. And that's why we're asking for a speedy conclusion to most of these appeals so that we can now get on to the heart of the matter.
So when you look at, of course, why such kind of actions, the actions to prosecute are being challenged is because people feel that they're unfairly targeted or the investigations have been rushed. So how do you help the DPP to be certain when he is investigating or even before recommending prosecution of certain issues, how do you help him to ensure that such kind of challenges do not emanate because the evidence is so concrete? Well,
the process of prosecution, first of all, commences with the investigation. Once the investigation is complete, the report is then taken to the DPP. His office then evaluates the evidence, and once the office confirms that there is sufficient facts to support a charge against that person, then they prefer the charge and say, yes, we recommend that the prosecution proceeds. Now, at that particular point in time, the DPP has got hundreds of state councils who are well versed in that particular area of confirming that, yes, this particular evidence here can sustain a conviction. Now, at that point in time, we as lawyers, of course, the DPP, all the state councils, state prosecutors are lawyers. And we, on the other hand, will be here to defend the accused persons. So it all boils down to this. The DPP's office under the Constitution, Article 157, he is an independent person. He cannot be directed by anyone as to how he's supposed to carry out certain prosecutions. So it's his discretion.
Right.
So we can't interfere with that discretion, by the way. Same thing, the way he decided to pick on the Queen's Counsel. It's a discretion that is bestowed to him. It's a discretion that he has a right to exercise, much as some of us may have a different opinion, but it's his right.
Right, and I want us to focus on something that you insinuated or referred to just a few minutes ago, and that is being arrested on Friday. We saw the arrest of the Law Society of Kenya member, the JSC, Professor Tom Ojenda, and he spent a weekend behind bars and then was released. Was it on Sunday, then arraigned on Monday?
Yes.
And you have been quite opposed to that. But when I look at the provisions of the Constitution is that part of the rights of an arrested person, they have the right to be brought before court as soon as reasonably possible, but not later than 24 hours after being arrested, or if the 24 hours ends outside ordinary court hours, on a day that is not an ordinary court day, the end of the next court date. So,
yes.
Even if you arrest someone on Friday, the next possible time you can take them to court is on a Monday, if it's not a public holiday.
Yes.
When you're opposed to this, do you feel like there's unfair targeting, or it's just the normal course of justice?
Actually, a few months ago, as President of Law Society, we wrote to the DPP, we wrote to the IG, complaining about Friday arrests across the board where citizens are concerned. We're not talking about lawyers, we're talking about citizens.
Right.
I'll give an example. On many occasions, I've had clients call me in desperate need, saying that the county, for example, the county inspectorate has arrested them on Friday at the business premises, in industrial or whatever, or in their shops. And the common trend has been Friday arrests. Why? Because you're arrested on a Friday, and then that brings in this element of coercion, that if you want to be released and not spend the weekend, then either corruption creeps in.
Is that happening, or you suspect?
It's happening. It's happening. In fact, it's one of the things that find out. Go to City Court. Go to City Court on a Monday to a Friday and look at the charges over there. Most of these charges, I'll come to that later. But the point is, Friday arrests, and the reason why we're opposed to them is this. If you've been investigating an accused person for weeks or even months,
right,
isn't it unjust to wake up one day come to the person's residence. I've even had one accused person I'm aware of who was picked up at 1 a.m. in the morning. This is the mother with children. She works as an in-house counsel in a parastatal, and she's picked at 1 a.m., spends the weekend. Over what? I mean, is that fair? We have had cases where you're taken there. It's more like punishment. You're presumed guilty. You've not been charged, yet you've had the opportunity of being arrested on a Monday, Tuesday, Wednesday, Thursday, or even Friday morning so that you could be released on bail. The same Constitution says that unless it's a very serious offense like murder, attempted murder, treason, or anything to do with terrorism, whatever, or you're a foreigner, where you can be reasonably held in custody. Otherwise, you are entitled to be released on bond, on police bond, and appear the following day, working day, when the court is sitting.
Someone might ask you, when the NYS suspects, dozens of them were being arrested, some of them over the weekend or on a Friday, you didn't speak out. But when Professor Tom Ojenda was arrested, then we hear all these voices.
But you see, that's a point of misinformation. We as a society, what we do is we write. And that is the first rule of engagement. Write a protest letter about this thing. And I did write the protest letter. And I did get a response from the police. What did the police say? We shall continue with these arrests. It is our constitutional right, as a statutory right, and we will not be stopped. So what have we done as a law society? We have already drafted a petition, and it should be filed either today or tomorrow, where we're challenging the issue of arrest. We're challenging the right of an accused person to be admitted to bond immediately. In fact, the other day, remember this case of Ongata Rongai? It was in the papers, and I just read the judgment yesterday. 20 petitioners filed suit against individual police officers who arrested them at night. 19 suspects were kept in a Land Cruiser for 3 hours. Now, can you imagine 3 hours cramped in that Land Cruiser? Then they were taken to, they were released at about 12:15 a.m. in the morning. The following day when they went, they found that they were charged with idling. And they were never taken to court. The lawyer was arrested and accused of being drunk and disorderly. So when the Constitutional Court delivered its verdict, what did it say? It found that the power of arrest was maliciously used by the police. It awarded the citizens 200,000 shillings each in damages, and the lawyer 3 million shillings. And the judge went through a very elaborate analysis of the powers of arrest in Canada, in America, in Kenya, and concluded that you have to obey the law. And one of the declarations was that if you're arrested and you're facing a fine or a maximum of 6 months in prison, you must automatically be issued with a police bond. You must be released. You can't be detained overnight.
Right.
This is what we're all talking about. The law is crystal clear. But citizens out there must appreciate this. We are fighting for your rights. We want to ensure that you will not face those malicious arrests by police officers who may be out there just to coerce you or may just be out there to victimize you. We want to ensure that the minute you're arrested, whatever day it is, you will be entitled to a bond, especially for these small offenses, and which, are, by the way, are the majority sum that afflict Kenyans today.
And as a body that represents the public interest, you see, what you're saying is according to the law, but several Kenyans are ignorant about that fact.
Yes.
What programs would you be considering to start to do or to execute to help them understand that? Because the first thing that people think once they're arrested is a bribe to secure their release.
Good. One of the things that I realized over the years is the problem of the rights of accused transcends not just ignorance of the ordinary mwananchi, but even the judiciary. For a number of years, when I would appear in the city court on criminal matters affecting clients who've been charged with various offenses relating to food, drugs, and under the Food, Drugs and Chemical Substances Act. I'll give an example, and you'll laugh at this. For decades, if you're a shop owner or a business owner and you've got goods which have expired, under the Act, the Food, Drugs and Chemical Substances Act, if a public or health officer comes over and says this particular product has expired and gives you a notice, you are entitled to immediately write to the public health department and say, I agree this product has expired. I invite you now to destroy that item. Do you know what they do? They don't follow that. They don't inform the citizens that. The court does not even look at that particular aspect. They then come and arrest you, and then they charge you, and the fine is the general penalty in the Act, which is 500,000 shillings. Now remember, the very first instance, the citizens had a right to say, protest and say, come over and destroy it.
Right.
The minute it's destroyed, there's no evidence, isn't it? You have cured the effect. You're not supposed to go through the criminal process. But now, assuming you go through the criminal process, under the subsidiary legislation, that attracts a fine of averaging 1,000 shillings. Now what happens is, the ordinary poor mama mboga in the streets is hauled up and she's told, now, mama, you need a 50,000 shillings cash bill. On a matter that should not even have been offense in the first place. Now that is what we want to transform. And one of the first things that we did as a law society when we met with the DPP as a council, and I put it to him and I said, look, we must evaluate the charge sheets. We have something in law called duplex charge sheets. Duplex charge sheets basically mean this. You're faced with a count, but you don't know what count you're facing in terms of the penalty. Now, in this particular case I gave you, where they give you a penalty of 500,000 shillings,
right,
that penalty only applies when there's no specific penalty prescribed to it. Now, what they do is they don't give you the actual penalty of 1,000 shillings in the regulations, because your offense falls within the regulations. So we agreed that a task force will be set up, which has been gazetted, which will evaluate and review all those charges in Kenya across the board, so that in future ordinary citizens know their rights, that the minute you're charged and the fine is 1,000 shillings, you'll pay it on the spot. Right. If you don't challenge it. And then you're released. But as we speak now, the biggest dilemma and problem we've had is that we lawyers have had the problem of not reading the law, understanding that this charge is duplex, this charge should have been under this particular regulation. So at the end of it all, you now plead again and say, okay, fine, we plead guilty, then you find someone being paid, charged 30,000, and remember it's per count. Right. Maybe there are 10 items, each item attracts a separate count. So you'd end up having a businessman who's an ordinary kiosk operator paying hundreds of thousands of shillings, but they can't pay that.
Does that money go to the government, or it's...
It goes to the government.
Okay.
Yeah, it goes to the consolidated fund.
I want to focus on something else in the fight against graft that you have seen over the past few months, and that is to do with the search warrants, or rather the houses being raided by EACC officials or the officials that are investigating different cases. And there has been people who are opposed to this kind of treatment, some of them saying that it's an abuse to right to privacy, but also it's part of the process that you want to go ahead and do this investigation. So how do you reconcile all that, the interest of justice, that you have to search somebody's house, and also the rights of this, this person?
Well, let me give you an example from the perspective of us lawyers, where we have search warrants issued against lawyers who are suspected of whatever crime that the police are investigating. Now, search warrants are provided for by the law. But also search warrants have to be very specific as to what you're searching. Because you can't have a blanket search warrant going over, breaking everything, taking away everything, yet the offense that you are going to be charged with is defined. So by the time a search warrant is issued, the magistrate should be very concerned as to how far and how wide is the search going to be conducted. For example, if it's an offense dealing with money laundering and you want to identify particular bank accounts, those bank accounts will be frozen. You want to identify particular books for that particular client. Because we as lawyers have a solemn duty of advocate-client privilege. We have numerous other clients. Now, when someone comes over and takes away all my computers that contain confidential information for those other clients, that is wrong. That's an illegal search warrant. The search warrant should be very specific, that you want information pertaining to this particular complainant, and you zero in it on books of accounts or files, or even or anything else that you feel is necessary only for that particular client, but not a general blanket client order for everything. That's where we oppose those particular blanket search warrants. So
when police officers or investigating officers get to a house, they're looking for something, and then they find other things that are not related, like guns, what is the place of that kind of finding in all this, in the entire process?
Well, no. Of course, it happens in those particular instances. Like, if they find guns, the first question they'll ask you, do you have a license for them? Now, if you don't have a license, that's another offense that is now created. And then they can charge you for that particular offense, if you're not a licensed gun holder for that. That's a different thing. So along the way, if it stumbles that another crime has been committed, then they'll be perfectly entitled to now charge you for that.
Okay. There are people who've been complaining about their relationship with their lawyers. You hear several complaints about, I was involved in a civil case, a lawyer was representing me, maybe it was an accident or it was a health-related issue, and then an award was given, but I never saw that money.
Yes.
Are you still receiving this kind of complaints like it should be through your tribunal, or people are just complaining at the periphery without knowing what course to take?
No, in fact, what we have is we have a two-tier system of handling these complaints. We have the Advocates Complaints Commission, which will be the first avenue to listen to the complaints and ascertain whether there's a particular offense that has been committed or a particular professional ethical infringement that has taken place. And then they'll advise the client. They'll even bring the advocate on board. Now remember, one of the things that also the Constitution promotes is ADR. At times, it may be some misunderstanding. At times, this lawyer has generally failed to account for the monies. Then the next course is you go to the disciplinary tribunal. Now, the tribunal is a very simple process. Any client with evidence of that will now file an affidavit of complaint. That will be filed in the tribunal. The tribunal then issues a letter to the lawyer telling him, this is a complaint against you, can you give an account? So there's a process that takes place because the tribunal sits every month and they will investigate the complaint. If the complaint warrants a conviction, the lawyer will be convicted. And that could be either he'll be ordered to refund, a judgment will be entered summarily against him for that amount, he'll be ordered to refund that. He could be struck off the roll. He could be suspended. So there are various many several mechanisms that will ensure that the client will get justice at the end of the day. And it's faster than even going to court. At times, a client will go to court if it's a matter of professional negligence.
Right.
And that's a different thing altogether. But for these things, the Advocates Act does provide for mechanisms for citizens, clients, to go and ventilate the grievances.
And how often do you see such kind of cases coming to you?
They're there. I mean, we're one of the few that who report we gazette, the Advocates Complaints Commission, for example, does, I think, a quarterly gazette notice of all the complaints. So we're quite open. We'll say, like, in this particular sector, these are the 4 complaints, these are the ones that concluded, these are the ones that refer to the DT. So we're quite transparent about that.
I want to ask you a question about like what has been happening recently of arrest of lawyers who were implicated or suspected to be involved in bringing down major institutions. And you see, a lawyer will be in court to defend the rights of the accused person. Or if they're on the prosecution side, then they are prosecuting the case for the Republic. So is it a moral complexity for lawyers to have to represent people that are likely to be guilty, yet you have to charge, you have to take fees that are most likely are proceeds of the same things that are alleged to be proceeds of crime?
Well,
how do you reconcile that as a lawyer?
It was very simple. I mean, there's always that popular misconception that we lawyers, as Shakespeare said, the first thing to do is to kill all the lawyers over the centuries. But remember one thing. Let's start with the Constitution tenets of presumption of innocence. Every person is presumed innocent until proven guilty by court of law.
Right.
Right. Number 2, we as lawyers have a duty to truth, justice, and the rule of law. Number 3, it is the burden, it is the prosecutor to prove beyond reasonable doubt that the accused person is guilty of that offense. Now, those are the ingredients that have to be followed. Now, on the issue of payment, if I'm paid by an accused person, is it my duty to find out whether this is a process of crime? I have raised a fee note and I'm paid by it, by the client. Remember that time, some of these clients, their accounts have been frozen. And at times, even relatives come over and raise money to pay for those legal fees, because every person is entitled to legal representation.
Right. What are your thoughts about, we have seen, there's that presumption of innocence that you're proven guilty by the court of law.
Yes.
But in this country, for instance, if I look at the case of NYS, Principal Secretary Lilian Omolo, Richard Dubai, who was the Director General NYS, as soon as they were arraigned before court, they were suspended. They're out of office. Then you look at and the PS is a state officer. You look at another state officer, that, like the National Land Commission chairperson, Mohammed Suzuri, he's taken to court, then he goes and fights his way back through the courts and he's back in office. is there a more superior state officer than the other? What is your view about certain officials, including governors, who are before court facing certain charges, but then they are released to go back and continue their work?
That's a good point, because unlike the West, for example, if you are accused of any crime, you would actually resign. In fact, many years back in Japan, you'd even commit suicide. They'd call it harikiri. But the point is this. Recently, in the last 1 year, the Kenya National Human Rights Commission went to the Supreme Court for an advisory opinion on this very issue you've raised, and the matter is pending in court. But all I can say is this. They want a constitutional determination on Chapter 6. And what they're seeking is simply this. Is it right for a state officer to continue being in office when facing corruption-related charges or any other charge related to that office? Should that officer not step aside pending conclusion of the cases? That matter is actually before the Supreme Court. And the only thing that why it has not been delayed is that one interested party came in to challenge that and said, no, I cannot, you should not proceed with this case because I've raised similar issues in the High Court. But this is a matter that we're waiting eagerly to find what the Supreme Court will guide, because it will now have a ripple effect across the board. As you rightly pointed out, it will now ensure that every state officer will equally face what the law prescribes and what the advisory opinion will come out with. So it's something that we are anxious and hope that the Supreme Court will deliver a determination this year.
Okay, all right, you're such a lawyer. I cannot get your thoughts about it, but it's okay.
No, actually, the point is, what I've made is very simple. That the Supreme Court will decide if you're charged under chapters, and then is that an infringement of Chapter 6, should you continue being in office? That's what I'm saying. Okay. So that's what we're waiting for, actually.
Okay, the Supreme Court will determine. Then
no, that's why I don't want to talk about it, because it's a matter actually pending in court.
And that's fine, fair point. My final question is that when you have these prominent cases, talking about the DCJ, talking about Professor Tom Ojienda, we see a battery of lawyers flocking the courtrooms to represent the interests of those persons that have been accused. But when we see the rest of Kenyan citizens who are not very known, it's the access to these lawyers is quite limited. Do you appear before a court to defend those persons on invitation of those clients, or it's just your own pro bono and generosity that you see such kind of a thing? Well,
it's a trend which has been there. Actually, it's not something new. It has been there for decades. Every time a lawyer faces any action in court and is accused of anything, then lawyers in solidarity band together to support. Take, for example, like when our brother Willie Kimani was murdered because he was representing a client. We all rallied behind him. Now remember, we're a fraternity or brotherhood of lawyers who will always stand up for one. And all these times you've seen this, is normally lawyers who would band up when one of them, whether in the judiciary, whether in private practice, is accused of anything. Now, when it comes to the ordinary citizen, one of the things that we're trying to do is to ensure that citizens are entitled to legal representation. Now, under the Constitution and even the Legal Aid Act, every citizen accused of a criminal offense is entitled to a lawyer. The problem now we have is funding. And one of the things that we as lawyers want to do, and one of the things that I personally would like to propose to Parliament, is to amend the Legal Aid Act. You asked one thing, where do those fines go to? And I told you they go to the Consolidated Fund. So one of the things to ensure that we have a pool of money to assist in legal aid is, why don't we get a percentage of all those fines which go to Parliament, so that we say, fine, in this year we have 500 million shillings in fines countrywide. Why don't you say 40%, for example, goes to the legal aid to provide a revolving fund for pro bono lawyers? Because even pro bono lawyers, by the way, have to be paid. Even in the West, there's a legal aid fund. Now, the sad thing is, in most jurisdictions, even in England, I understand, I spoke to an English lawyer the other day, and they said that even their own legal aid fund is not really supported by the state. So we want to come up with something novel. Get the guilty who pay fines, sustain the legal aid. Get a percentage of that, because it's not even a loss to the government, because the government cannot project that I'm going to have 1 billion shillings in fines. All we're saying is a percentage of that should go towards the Legal Aid Act, and that's what we're going to propose. In fact, as President of Law Society, the first quarter of this year, one of the things that I'll target is legal reform, and that is one of the areas of legal reform that we want to take to Parliament. We also want to engage with our parliamentarians and and see how we can lobby for expedited reforms in various areas, in the criminal justice system and various aspects that affect the Kenyan good. Like, for example, last year I petitioned Parliament as a citizen to come up with a fraud act because I was concerned about corruption by directors who hide behind the corporate veil and say, oh, sorry, the company is now bankrupt, it's insolvent, I can't do anything, you can't touch me. So after I did my research, I went to Parliament with the petition. Parliament considered the petition, forwarded the Kenya law reform, and the committee came with a recommendation saying that I had raised valid points and that the Attorney General should now consider amending the laws either piecemeal or come up with a comprehensive fraud act that will target those directors of companies who use a corporate institution to defraud Kenyans.
Right. Great. And I want to look at some of the feedback that you've been tweeting us at Citizen TV, Kenya, Gichuhi. The hashtag is Daybreak, and also what you've been texting us on 22422. So Ishmael Nyaribo says that the DPP must appreciate his work and respect the office as it is. His work ends where the courts begin. I'm not sure that's true. The battlefields change in the court when the courts take over. He should not purport to instruct courts how to effect the DPP's mandate, as that is not the court's role. What are your thoughts about that?
Well, look, every institution, every arm of government is independent. And there's truth in the statement. No one should dictate to a judge or a magistrate as to how the judge should deal with the matter. For example, when it comes to the bail bond policy, the judiciary came up with the bail bond policy, I think, in 2015. Why? Because there's an outcry over the disparity of bail term conditions. You'd find a chicken thief ordered to pay maybe 20,000 shillings. Then, in comparison to a chicken that's worth 800 shillings.
Yes. Or
500 shillings, depending how skinny it is. Now, you go to someone who's stolen billions and is out on a bond of 500,000 shillings. So that's the discretion that the judicial officers have. And you can't dictate those terms. So the DPP, no one, not even the president of the country, can dictate to the courts and say, you must have this person convicted. Because it's an independent office. And we must respect that.
It's based on the evidence.
Absolutely.
Right. As we conclude this, Mr. President, I really get to talk to presidents. Today I'm lucky.
I don't have an official flag.
Don't worry. Keep your dreams alive, if you're interested in politics, that is. But a few months ago, there are some people who wanted you out of the Law Society of Kenya. I want you to respond to that, how you have been able to contain that, and also combine it with the Law Society of Kenya agenda for 2019 as we get into the year.
Well, to be honest, I mean, with political office, because mine is almost like a political office, we have different elements of members who have different views and points of view. So a motion was drafted by one member who felt that I and one of my council members should not have stood for office because the old LSK Act transitioned to a new act, and the new act had a transitional clause that said that if you're a former council member, you cannot vie for any position afterwards. So that motion was never tabled, because for you to table such a motion, you have to first of all go through the LSK Act and go the procedure of removal of any council member, which is a very elaborate process, because first of all you bring a notice to show cause, then I would have the right to respond, and then if I'm found guilty, then a general meeting has to be called within 30 days, and 2/3 of the members have to decide that whether I'm fit to be in office or not. So the whole process died what you call an infantile, it has suffered from an infantile mortality rate, and we never admitted it, because the special general meeting we called for was specific one purpose, and you can't bring any of the motion. But now, going forward, what's my agenda for 2019? I have set out with my council quarterly targets that we want to achieve. Because you have to appreciate that within 1 year is not a long stretch of time. But when I first ran for office and I was asked, are you really going to achieve all these things that you're going to do within this period of time? I said, why not? At that time we had 15,000 members, now we're going to 16,000 members. I have enough members that I can call upon with my council to assist us in reform. And believe me, with that particular agenda in mind, Within 6 months, I accomplished 90% of my specific targeted goals of assuming office. For the first time, we are coming up with a pension scheme for lawyers. Never before in the history of the Law Society since 1948. For the first time, we came up with an office manual within 2 months. Because one of the things that I am a bit impatient about is results. I want things done very quickly. So what you do is you identify colleagues out there who will assist the council in bringing about reform for the greater good of the members. So we've also come up with a bar bench guideline. Now that's an important guideline because part of the guideline is a template on judicial performance, which I created in 2016. Because when you talk about corruption, when you talk about complementing the judiciary, we must have a clear-cut framework because it's unfortunate to come up with false accusations against a judicial officer without a clear guideline. So we created that template together with the branch chairs. And now if there's any complaint by any lawyer, that template is out there to be used. Now, the best I can do as a president, as my council, is we provide the enabling environment. It is up to the members to use those tools. We also are engaged with the senior council because, you know, we have this rift of young lawyers and senior lawyers. So we've engaged with the senior lawyers and we've come up with a mentorship program. So a body will be set up which will actually oversee a mentorship scheme for young lawyers who want to improve in their practice. And that's something that I'm really looking forward to launching. When
you talk about the young lawyers, how many are you talking about?
Well, on average, you admit between, say, 1,500 to 2,000 young lawyers every year.
Every year.
And when you look at the current demographics of the society, the young lawyers, I would probably say, constitute maybe 50 to 2/3 of the population. And you're a young lawyer between 0 and 5 years. The minute you cross the threshold of 5 years, you cease to be a young lawyer. You now become a senior lawyer compared to them. So those are the things that we really want to help them out with. Because we appreciate the challenges. We have challenges pertaining to salaries. We have challenges pertaining to placement, jobs. We have challenges pertaining to proper work ethics. We have challenges on how do you carry out your work professionally.
Right.
And that is what the mentorship program wants to assist you in. Make you a better lawyer. Make service delivery to the ordinary Wananchi better and professional.
And of course, I'm asking that question because you will, during the elections, the LSK elections last year, there's some of the lawyers who are saying that it becomes so hard for them to get into the industry, to practice whatever they have been taught in school, bearing in mind that many of the accused persons would rather go for senior lawyers. So if that mentorship program would work, then I hope it will be specific to bring up some of those that are still...
No, absolutely. So the mentorship program is cross-cutting in various disciplines of the law. So if you want to be, you want mentorship in criminal law, in civil litigation, in conveyancing, family law, that is where we'll now have a pool of mentors who will now come and guide. For example, the challenges we've had is that we have a lot of brilliant lawyers out there who have a lot of knowledge. And that is why we want to bring them out on board to assist in uplifting the professional standards of the society.
All right.
So that we are the premier bar. I mean, we're the largest bar association in East and Central Africa in terms of numbers.
Right.
And we want to lead by example.
Okay. All right. Thank you so much, Mr. President. I want to just read one tweet that has come from Macharia Njeru. He says that corruption undermines legitimacy, public trust, and the rule of law. Preventing and fighting corruption must be prioritized in order to safeguard the foundations of democracy, justice, and effective governance. So that has been Mr. President, the Law Society.
Always a pleasure.
Thank you for coming and joining us for that conversation on Daybreak. I think this continues, law and corruption. Of course, lawyers play a critical part in the criminal justice system, and it would be good that if the lawyers eventually are seen to actually supporting those goals of the country.
And we're actually doing quite a bit of that, believe you me.
Thank you so much.
Okay.
Daybreak continues, but now take a short break. We'll return in a short while.